Hey everyone, Harry here to talk about the motion to revoke Harrison Floyd's bond in Fulton County yesterday and how it all went down. Point one, Fonnie Willis decided to argue it herself. It's the first time she's made an appearance in the case. I was the head of an office, a federal prosecutorial office, and I'm here to tell you that guarantees instant attention and focus and pressure on the top dog. You really don't want to go in there, pick your spot, and lose. And she didn't quite do that, but she certainly didn't quite win either. So the motion that she made and very forcefully argued for said that Harrison Floyd had intimidated witnesses and had violated his conditions of release, had communicated with them and intimidated them. And he had done some tweets, had Floyd, who seems to be kind of a nut. He has suggested he's going to defend his case on the ground that, in fact, the election was stolen. He's the only defendant so far to have been in jail because when he first showed up, he didn't resist bonds. He spent 17 days in jail before being sprung. So he's an oddball for sure. But Willis stood up and very emphatically in front of McAfee several times called his lawyers liars. That's something you do very sort of sparingly, but she, really doubled down. The communications, I thought she was a bit out front of her skis because the communications, what Floyd's lawyers were able to say was, look at this order, Your Honor. It tells us not to intimidate. I don't think we intimidated. Now, she had evidence, did Willis, that among others, Jenna Ellis, who's going to be cooperating, said she felt intimidated by a social media post that Floyd had offered. And Ruby Freeman, his whole role in this case was to really participate in the terrible pressure campaign against Ruby Freeman and Shay Moss. And the charges against him have to do with basically browbeating them and telling them they're going to go to jail if they don't show that there was fraud, etc. And there were every time he mentioned their name, which he did in a couple posts, they testified they had tons more of hateful messages. On the other hand, intimidation, certainly not by Trumpian standards. He did mention them, and there's the inevitable consequence in the sort of, marketplace. The other real technicality was he communicating with these witnesses or about these witnesses? So you can't call up a witness and say, like if you're Trump in particular, just want you to know that, I really value your loyalty or whatever, but a communication about that seemed not as clear. So Judge McAfee wound up saying, he again showed himself, I'm really impressed with McAfee. He's young, good Federalist Society guy, etc. People wondered at first, but he runs, he's level-headed and does his homework, etc. And so here he found what he called a technical violation because of, this was sort of communication with, or maybe he meant kind of intimidated, whatever. But he said not every violation should result in the yanking of conditions of release. So instead, he said we should really clarify the conditions themselves. And along with the parties kind of went to the side and rewrote them, and he adopted a statement. And the conditions are now way more detailed and way more restrictive. It makes clear you can't talk about that. It really basically shuts him down. And what makes it clear on social media too, that one of his points, Floyd's, had been, look at, say, the condition of release for Donald Trump. It specifies social media. In my case, it doesn't, so that shouldn't count. Well, now it does. So on the one hand, he called it a technical violation and did not adopt her sense of real, the outrage. But on the other, at the end of the day, there's a much fuller set of restrictions that Floyd has to deal with. Okay. So to me, it's noteworthy that Willis comes out of the box and so strong. And it's noteworthy that McAfee pushes back somewhat, at least doesn't yank conditions of release. And my analysis of this, my best guess is that both of those actors were thinking of someone not in the courtroom, and that would be, no surprise, Donald Trump. So that when Willis decided to come out guns a-blazing, I think she wanted to send a message, and in particular to him, that if you try to intimidate witnesses and talk the trash that you have been doing all over the country, that's already a violation of your conditions of release. I don't need a gag order to go after that, and I will go after that and file a motion to yank your conditions of release. And you, Donald Trump, with no more, will be looking at being incarcerated in Georgia State Prison until this trial. So I think she was sending a signal, and to the other defendants as well. And that, I think, is, an explanation both why she chose this one and why she was really so strident. McAfee, on the other hand, he doesn't want to be, nobody does, the judge who finally orders Trump into jail because of his incessant campaign of absolute outrageous intimidation of witnesses. And if he had acquiesced to the motion by Willis, it seems to me the next time when Willis comes and says, look now what Donald Trump has done, and it would have been so much more than what Floyd had done, McAfee would either have to say, flat out, well, the law's got to be different for him because of the First Amendment things, the same kind of issue that's being, wrestled with right now in the DC circuit in the Chutkan case. Or so he would basically have to either say, well, we don't treat all defendants alike, which is something that judges and the law in general is, really reluctant to say, or he'd have to put him in jail, which is, really not what any judge wants to do, and certainly not before a whole series of warnings. And if you put Floyd in jail right away without warning, but then Trump, you give a warning and another warning and another warning, it really looks like preferential treatment. So I think both Willis's her choice to do it, her very aggressive presentation, and McAfee's decision that basically, gave her not quite half a loaf, are best understood through the prism of Donald Trump, who of course hovers over all these things, every day. So anyway, that's the bond hearing. We'll see if she's also sent a signal to the other defendants. So we'll see if people are much quieter there than Trump has been everywhere else. And, in terms of quiet there, we've talked before about her moving for a date in August. And, on the one hand, that stakes out a day that maybe she thinks will hold. But as I've said before, I think the triggering event for pleas and, which really will, kind of, put the finishing touches on her case, usually is setting of a date, as it was before. There was the date for Chesbrough and Powell, and that triggered a flurry of pleas. Now we're talking August, and so, maybe the other defendants, they're in no particular rush. They're paying some money out every month for their lawyers, but the real pressure is when you're thinking about swearing a jury. That's really when pleas go down. And so, they may not be. That's one of the collateral consequences of setting such a late date. The other one, well, first, as I suggested, since she says it'll take 4 months, if that date holds, and can't imagine it being an early one, no way, that the case completes before the end of the election. And indeed, it poses what is going to happen if it comes to November. It's still going on. And Trump has, just won the presidency. What a terrible mess that I think well, I'm getting way ahead of myself here, but you can see the complications. And then moreover, Judge Cannon, who loves any excuse for delay, she now can be looking ahead. She's already laid the groundwork for a delay based on the classified information litigation. She'd be looking at probably August at the earliest, and here's this 6-month bump. So I'll see you also in 2025. So that's both of them together to me suggest the focus needs to stay on Judge Chutkan and the January 6th trial. But okay, so that's the, somewhat dramatic back and forth with the DA herself making the argument, and Judge McAfee fairly cool-headed, saying violation, but I'm not going to yank his conditions. And I think everybody in the courtroom having their, eyes, one eye on what could happen in the future to other defendants. So that's where things stand. I will see if there's pressure for pleas coming. It's less so. So it's on the horizon is just going to be some pretrial motions and not a ton of action unless somebody takes a plea or there's some kind of movement on the trial date, which I don't anticipate. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.